Welcome to class, students. Today we are diving into a strict, high-yield academic explainer. We're dissecting question 19 on the contract of sale to create the absolute perfect blueprint for your KSLU answer scripts. I am your professor, and my goal today is to ensure you don't just understand this topic, but that you conquer it in your examinations. Okay, let's get right into this. Pay very close attention to the exact structure we use here, because this is precisely what your evaluators are looking for.
Here's our agenda for today's session. 1. Introduction and definition. 2. Essential elements. 3. Meaning of sale and agreement to sell. 4. Distinction table. 5. Case laws. And 6. Importance and conclusion. You must write this exact heading structure on the very first page of your answer booklet. Doing this instantly shows the KSLU evaluator your organizational clarity and your absolute command over the subject. Right, let's move to the first heading.
Section 1. Introduction and definition. We begin with the foundational statute governing movable goods. Let's read it. Introduction. Governed by the Sale of Goods Act 1930. Section 4 defines contract of sale and explains the distinction between sale and agreement to sell. Okay, listen to me carefully. You must cite this immediately in your opening paragraph. After writing this exactly as stated, I want you to take your black pen and explicitly underline Sale of Goods Act 1930 and Section 4. Please do not skip this step. It instantly captures the evaluator's attention and establishes your legal authority right out of the gate.
Now, according to Section 4, a contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property and goods to the buyer for a price. I'm going to dictate this again for your mental retention. A contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property and goods to the buyer for a price. I am pausing deliberately on transfers, agrees to transfer, and price, because these are the strict statutory requirements. Mark my words, if these exact terms are missing from your definition, you are going to lose marks.
Moving on, Section 2, Essential Elements. Now we look at the 5 pillars that constitute this contract. These are absolutely essential for scoring maximum marks in any 10-mark or 16-mark question. Essential elements. 1. Two parties, seller and buyer. 2. Transfer of ownership in goods. 3. Goods must be movable property. 4. Consideration must be price, meaning money. 5. Contract may be absolute or conditional. Note these down meticulously. I'm warning you right now. Missing even a single one of these 5 elements will cause the evaluator to severely slash your marks. And remember, under the Sale of Goods Act, if the consideration isn't price, say it's goods exchanged for goods, well, that's a barter, not a sale. Keep that technicality in mind. Section 3. Meaning of sale and agreement to sell. Next, you need to systematically define the 2 distinct subtypes of this contract as dictated by Section 4. First, meaning of sale. Ownership transferred immediately. Features: executed contract, buyer becomes owner instantly, risk passes to buyer, seller can sue for price. The example: A sells his mobile phone to B for 20,000 rupees and immediately delivers it. This is a sale. Now, what's really critical to understand here is that term executed contract. The transaction is complete. Because the buyer becomes the owner instantly, the risk moves simultaneously. Quote this exact mobile phone example on your paper to show practical application. Contrast that with the meaning of agreement to sell, transfer of ownership postponed to a future date or conditional. Features: executory contract. Ownership remains with seller, risk remains with seller, buyer gets contractual rights. Example: agrees to sell his car to B after full payment next month. So contrast this executory nature, and please, that word executory is vital, against the immediate sale we just discussed. Because the ownership is postponed, the seller strictly retains the risk. If that car gets damaged before next month, it's the seller who bears the loss. Section 4. Distinction between sale and agreement to sell. We now arrive at the absolutely most critical part of your 16-mark answer, the tabular distinction. This must be drawn perfectly. Instructing you right now, take a fresh page in your answer booklet to draw this exact table. Draw clear columns. Let's read across the rows based on the basis of difference. Meaning, in a sale, ownership is transferred immediately. In an agreement to sell, ownership is transferred in the future. Nature: sale is an executed contract. Agreement to sell is an executory contract. Transfer of property: immediate for a sale, future or conditional for an agreement to sell. Passing of risk: in a sale, risk passes to the buyer, whereas in an agreement to sell, risk remains with the seller. Continuing the table: ownership: buyer becomes owner in a sale, Seller remains owner in an agreement to sell. Right against goods. Buyer gets rights in rem in a sale. Buyer gets rights in personam in an agreement to sell. Insolvency of buyer. Seller may sue for price in a sale. Seller may refuse delivery in an agreement to sell. Remedies. Action for price in a sale. Action for damages in an agreement to sell. Now pay attention. The crucial point here is the difference between rights in rem and rights in personam. Write this down clearly. Use in rem means a right against the whole world. You buy a phone, it's yours against the whole world. Use in personam means a right against a specific person. In an agreement to sell, you only have a right against the seller to demand the sale, not against the goods themselves. It's a massive, high-scoring difference.
Section 5. Case laws. No KSLU answer is complete without citing legal authorities to substantiate your statutory definitions. If you want a top grade, this is exactly where you earn it. First up, Tarling v. Baxter, held that risk generally passes with ownership. Write this case name in a separate boxed format on your paper. Let me explain the deep background of this case, which you must briefly summarize in your exam. The facts are, A agreed to sell a haystack to B. It was agreed the haystack would remain on A's land until B took it away, but the sale itself was finalized. Before B could actually remove it, the haystack accidentally burned down. The court's ratio decidendi, the final verdict, was that since the contract of sale was complete, ownership had already passed to the buyer, B. Therefore, the risk passed to B, and B had to bear the loss. The absolute relevance of this case, it perfectly proves our earlier distinction. Passing of risk follows ownership. Res perit domino, the thing perishes for the owner. Next case, Roland v. Duvall explained the effect where ownership in goods does not properly pass. Underline this case name in black ink to immediately capture the evaluator's attention. Let's break down the facts here. The buyer bought a car from a seller and used it for several months, but later it was discovered that the seller had actually stolen the car, meaning the seller had no valid title whatsoever. The true owner eventually reclaimed the car from the buyer. So what was the verdict? Well, the court held there was a total failure of consideration because the seller never had the right to sell the car in the first place. The buyer was allowed to recover the full purchase price from the seller despite having used the car for months. This brilliantly illustrates the absolute relevance of understanding remedies. When an agreement fails to legally mature into a sale because ownership cannot properly pass, the buyer's remedy is total recovery. Section 6. Importance and conclusion. Finally, we must conclude the answer script by summarizing the practical, real-world importance of these legal distinctions. Importance of distinction determines passing of ownership, passing of risk, rights of parties, remedies available in case of breach, and rights against third parties. Dictating these points directly brings the entire statutory definition into real-world commercial application for the evaluator. It practically screams to the examiner, I don't just know the textbook theory, I know exactly how this affects businessmen in the courtroom. Your conclusion must read exactly like this. Conclusion. A contract of sale may either be a sale or an agreement to sell depending upon the time when ownership passes. It affects ownership, risk, and remedies, playing a vital role in commercial transactions. Providing this neat, academically rigorous closing ties up your entire 16-mark answer beautifully. I leave you with this final, critical thought. If risk and ownership are so deeply intertwined, who ultimately bears the loss when commercial goods are destroyed before a conditional transfer is complete? I want you to really ponder the exact moment an agreement to sell transforms into a completed sale. The moment that invisible line is crossed, entire fortunes are shifted. Study the strict blueprint, apply it exactly as taught today, and you will absolutely excel in your examinations. Class dismissed.